Welcome. Today we're talking about a really interesting and important subject in Florida personal injury law, and that is Florida's comparative negligence law and how that affects your settlement in a Florida personal injury case. After an accident or injury in Florida, it's natural to assume that the person that caused it is responsible to pay your damages and your losses. But what happens in the situation where the other party's insurance company blames you for being partially responsible for the harms and losses? So for instance, if you're in a car accident, what happens if the other party's insurance company says you were speeding slightly? Or if it's a slip and fall at a premises and they say, well, you weren't paying close enough attention to where you were walking. If you were, you would have seen the wet floor. And so you're also partially responsible for slipping and falling on that wet floor. That type of defense that insurance companies use routinely, where they blame you or try to say that you're also partially responsible, in law in Florida is known as comparative negligence. It's an important legal doctrine that affects the value of your case, whether it's by settlement or if you have a jury trial. And so it's important to understand what this doctrine is and how it can affect the value of your case. Now, the legal doctrine of comparative negligence has undergone a big change in 2023. So before March of 2023, when the law changed, comparative negligence in Florida was what we would refer to as pure comparative negligence. So what that meant is whatever percentage of fault you were, it was just a simple math deduction. So as an example, if the claim was worth $100,000 and you were 60% at fault, you could only recover 40% of those losses, so $40,000 from the defendant. That was the pure comparative negligence method. But that's all changed. The law is completely different now. Florida has switched to what's known as a modified comparative negligence doctrine. And so under the modified rule, you can only recover against the at-fault party if your negligence is 50% or less. Let's use the $100,000 case as an example. If you are 40% at fault for that accident, you can now recover 60% from the defendant. You can recover $60,000. However, if you're found to be 51% at fault under the new law, you're completely barred. You're not allowed to recover any money from the at-fault party or their insurance company. Comparative negligence plays a big role in how insurance companies assess claims. They're always looking for opportunities to shift the blame to the person who was hurt because, of course, it reduces how much money you can recover. They do that a number of ways. They investigate fault. They look at physical evidence, witness statements, documents, whatever they can to try to shift some blame. Car accident case, for instance, they'll look to speed. Were you going slightly over the speed limit to try to say that you're partially at fault and they don't have to pay you quite as much? Let's talk about an example with a slip and fall case. You're walking through a shopping center or grocery store. You're not really paying complete attention. You're looking at your phone, maybe texting as you're walking, and you walk into a puddle of water on the floor and you slip and fall and sustain injuries. And for example, the case is worth $100,000. Now, if a jury found you 20% at fault because you weren't paying attention, looking at your phone, then your recovery in that case would be 80% or $80,000. Another example, you're running through a shopping center and there's a warning saying wet floors, they just finished mopping, and you just run past it, fully aware of it, and then you slip and fall. And under those circumstances, the jury decides to assign 60% fault for you and 40% fault for the store. In that case, under Florida's new modified comparative negligence law, you would be found more than 50% at fault, and therefore you would be barred. You would not be able to recover anything if the jury found you 60% at fault. So that's how the law has changed, whereas before you would still be able to recover. Comparative negligence, while it was always important, now, depending on the circumstances of the case, can be much more important, because it can make the difference between you recovering money or recovering no money, despite the fact that the other party also shares a considerable portion of the blame. So given the Florida comparative negligence law, it's not surprising that insurance adjusters almost always look for opportunities to shift blame or push blame back on you in order to pay less money. It results in a discount of what they pay. Insurance companies are very good at mobilizing quickly to preserve evidence and try to shift the blame. The bigger the accident, the more significant the injury is, the more likely they are to mobilize quickly. How can you protect yourself and maximize your chance of recovery? Well, the number one thing you can do is lawyer up quickly. Get an experienced personal injury lawyer working for you on your Florida case so that you can also mobilize quickly, preserve evidence, hire the appropriate experts where necessary, accident reconstruction, engineers on liability for slip and falls, etc. There's a number of experts that we routinely work with where liability is a contentious issue. Preserving evidence, building a case, and being able to fight back against the insurance company when they try to push blame where it shouldn't be. I hope you enjoyed this video. Feel free to leave comments below. We love your comments, and it gives us an opportunity to respond and also gives us ideas for future videos. We hope you found this video informative.